Welcome to today's episode of Courts This Week on LiveLaw. I'm Taniya Pandey, and it's time to get the important court updates of the week gone by. A Supreme Court bench of Justices A.M. Khanvilkar, Indu Malhotra and Ajay Rastogi has dismissed a petition seeking an extra chance in UPSC civil service exams for candidates who had exhausted their last attempt in October 2020. The petitioners had sought an extra chance, citing difficulties created by the COVID-19 pandemic and the national lockdown. The court observed that Rules 4 and 6 of the Rules for Competitive Examination 2020 prescribed the eligibility with regard to number of attempts and age respectively, with Rule 6 categorically stating that the age limits prescribed can in no case be relaxed. The court also expressed their apprehension that if such a prayer was to be entertained, it would have a cascading effect on examinations in other streams, which dissuaded them from exercising plenary powers under Article 142 of the Constitution. The Supreme Court has upheld the constitutional validity of Section 5, Subsection 3, Clause 3, Subclause A, and Section 29A of the Gujarat Provincial Municipal Corporation Act 1949, which provides multi-member representations from a ward in the municipal corporation or municipality. Articles 243R and S of the Constitution of India do not contain any limitation to that effect that there shall be only one member from one ward. The bench, comprising Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah said, while upholding the Gujarat High Court judgment dismissing the writ petitions challenging the provisions of the Act. The Supreme Court, while upholding acquittal in a murder case, reiterated that suspicion, however strong it may be, cannot take the place of proof, and that an accused is presumed to be innocent unless proven guilty beyond reasonable doubt. The prosecution case was that the accused had murdered the deceased by applying electric shock to him after administering some poisonous substance to him. The trial court acquitted the accused, and later the High Court upheld the acquittal. The Supreme Court in appeal, referring to the evidence on record, observed that as per the opinion of the doctor who had performed the autopsy, there is a strong possibility that the deceased was intoxicated and might have accidentally touched a live electrical wire while he was asleep. In a case before the Jharkhand High Court, certain appointees to the post of police sub-inspectors, attendants and company commanders had been terminated by the Home Department on the ground that the select list was prepared wrongly by ignoring merit of the candidates. The Jharkhand High Court allowed the writ petition of the appointees who were terminated and observed that they could not be held responsible for the irregularities committed by the authorities in the manner of selection. Some other candidates who had secured higher marks had also filed intervention applications, which were dismissed by the High Court. Agreeing with the High Court's view, the Supreme Court observed that relief granted to writ petitioners was mainly on the ground that they had already been appointed and had served the state for some time and could not be punished for no fault of theirs. In respect of plea of the interveners, the Apex Court observed that appointment of persons with lesser merit would be in violation of Articles 14 and 16 of the Constitution of India. However, in this case, the interveners could not claim parity with the writ petitioners. In an interesting case, a car dealer, Vistar Goa, sold a Tata 2009 model of a car to a customer under the pretext of a 2011 model. The customer filed a consumer complaint in the district forum seeking refund of the money or replacement of the car. Tata Motors was also made a party to the complaint. The district forum held Tata Motors and the dealer jointly and severally liable. Tata Motors appealed before the State Commission, arguing that they could not have held them liable for the dealer's fault. Their appeal was dismissed. The NCDRC, in further appeal, confirmed the findings of the state and district forums. Aggrieved, Tata Motors approached the Supreme Court. Allowing the appeal, the Supreme Court set aside the findings of the consumer fora as against Tata Motors and observed that a manufacturer will not be liable for the fault of the dealer unless it is proved that the manufacturer was aware of the deficiencies of the dealer in cases where the relationship between them is on principle-to-principle basis. The Supreme Court has observed that the regulations of fee for MBBS students in private self-financing medical colleges is within the domain of the Admission and Fee Regulatory Committee, which has to ensure that the fee is non-exploitative and reasonable. The bench of Justices L. Nageshwar Rao and S. Ravindra Bhatt observed that the committee can direct the managements to furnish any information that is required for the purpose of arriving at a decision that the fee proposed by the managements is neither excessive nor exploitative in nature. The Supreme Court has observed that family settlement can be entered into by a Hindu woman with her heirs on her parental side. In this case, a widow had settled the property she had received as a successor from her husband in favor of her own brother's sons. The trial court passed a consent decree in this regard and declared the sons as owners. Later, the descendants on the side of the woman's in-laws filed a suit claiming that the consent decree is illegal. This suit was dismissed, and so was the second appeal before the High Court. Before the Supreme Court, one of their contentions made by the appellants was that as a married woman, the lady was not competent to enter into a family settlement with her own brother's sons. The Apex Court observed that the lady was the absolute owner when she entered into the settlement, and the heirs on her parental side were not strangers to the family. The court also held that a consent decree based on admission, recognizing pre-existing rights under the family settlement, does not require registration under Section 17, subsection 1, clause B of the Indian Registration Act. The Supreme Court has observed that the pension under the Swatantrata Sainik Samman pension scheme can be sanctioned as per the proof required under the scheme and in no other manner. When the claim is under a particular pension scheme, unless one fulfills the eligibility criteria for grant of pension as mentioned in the scheme, no applicant can claim such pensions as a matter of right, the bench of Justices Ashok Bhushan and R. Subhash Reddy observed, while setting aside the Madras High Court's direction to grant freedom fighters' pension to an applicant under the said pension scheme. The Supreme Court has dismissed an appeal filed by a man convicted for murdering his pregnant wife. As per the prosecution, the accused had beaten up his pregnant wife, caused internal injuries and murdered her, and then made a false statement that she had suffered a cardiac arrest. The trial court convicted him under Section 302 of the Indian Penal Code and sentenced him to life imprisonment. The High Court upheld the trial court's judgment. Dismissing the appeal, the bench of Justices Ashok Bhushan and Ajay Rastogi observed that the prosecution had established a chain of events which left no doubt that it was none other than the accused who had murdered his wife. The Supreme Court has held that grant of essentiality certificate by the state government and consent of affiliation by the university is not simply a ministerial act. The court held that essentiality certificate is mandatorily required by a person before he receives permission for establishment of a medical college. A bench of Justices A.M. Khanvilkar, B.R. Gavai and Krishna Murari observed that state government has the power to withdraw the certificate where it is obtained by playing fraud on it, or where the very substratum on which the certificate was granted vanishes, or any other reason of like nature. The Supreme Court has directed Saraswati Medical College to deposit an amount of Rs 5 crores to the Supreme Court Registry for intentionally violating the Medical Council regulations by granting admission to students not allotted by the Director General, Medical Education. The court refused to condone the violation made by the college in providing admission to 132 students on its own and permitting them to continue despite Medical Council of India's directions to discharge them. The Supreme Court has observed that salaries and pensions are rightful entitlements of government employees, and the government, which has delayed the payment of salaries and pensions, should be directed to pay interest at an appropriate rate. Disposing the appeal, the bench directed that in substitution of the interest rate of 12% per annum, which had been awarded by the High Court, the government of Andhra Pradesh shall pay simple interest computed at the rate of 6% per annum on account of deferred salaries and pensions within a period of 30 days. The Supreme Court has observed that Order 7, Rule 11, which deals with rejection of plaint, is not exhaustive, and the court has inherent power to see that frivolous or vexatious litigations are not allowed to consume the time of the court. In this case, the plaintiff had filed a civil suit challenging a sale deed executed by the first defendant in favor of other defendants, on the ground that there was a preemption agreement executed between the plaintiff and the first defendant. The plaintiff stated that the said preemption agreement had been executed on the basis of power of attorney executed by the first defendant in favor of her son. The other defendants moved an application under Order 7, Rule 11, contending that there was no power of attorney authorizing him to enter into any such agreement. A division bench of the High Court allowed the application and rejected the plaint. The Apex Court, while dismissing the appeal, observed that the division bench of the High Court had done substantial justice by nipping in the bud a suit which is ex facie not maintainable for want of cause of action. The Supreme Court has observed that a wife levelling allegations which affect the career and reputation of her husband amounts to mental cruelty against him for the purpose of seeking divorce. In this case, the husband, an army officer, in his divorce petition, had alleged that he was subjected to numerous malicious complaints by the wife, which had affected his career and created a loss of reputation, resulting in mental cruelty. The family court granted the divorce, but the High Court reversed it. Setting aside the High Court judgment, the Supreme Court observed that there was error on the part of the High Court in describing the broken relationship as normal wear and tear of middle-class married life, and that it was a definite case of cruelty inflicted by the wife against the appellant. The Supreme Court has observed that ossification test conducted on a person aged around 40 to 55 years cannot be conclusive to declare him a juvenile on the date of the incident. A bench of Justices R.F. Nariman, Hemant Gupta and B.R. Gavai observed that when a person is around 18 years of age, the ossification test can be said to be relevant for determining the approximate age of a person in conflict with law. However, when the person is around 40 to 55 years of age, the structure of bones cannot be helpful in determining the age. Those were the top stories from this week. Thank you for watching. I am Taniya Pandey and I hope you have a lovely day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.